It is nice to see everybody and nice to see so many familiar faces. We recognize that we are the last panel standing before you and lunch. So we will try to make this as interactive as possible. We have a bit of a game, which is kind of a nerdy game, just to start off with. But first we'll do some introductions, and I'm gonna have each of the panelists introduce themselves because I really can't do justice to all of their amazing backgrounds. Just to start, my name is Michelle Ramirez. I'm a trial lawyer with Sidley Austin. I'm based in Chicago, Illinois. I'm involved in many different product liability and mass tort cases. In the last year, I tried 2 cases for Bayer involving Roundup, both successful defense cases. I'm also involved in the ultra-processed food litigation. I represent one of the major food and beverage companies that's named in that litigation. That is a brand new product liability case that we can speak more about over lunch, that's timely, filed in the US. And then I'm also involved in the talc litigation and the PFAS litigation. I've got a whole global perspective here, and so we'll just go in order, and I'll start with Katie. If you could just please introduce yourself to the audience and a little bit about what you do.
Thank you, Michelle. So I'm Katie Chandler. I'm head of litigation at Taylor Wessing's UK office. My practice focuses on the defence of product liability litigation in particular. I do a lot of medical device work, automotive. I'm involved in the Pan-Nox Dieselgate litigation that's going on at the moment, and also more recently a lot more in the autonomous vehicle space, advanced technologies, and a lot around sort of how the regimes are going to fit with all of those sort of modern day products.
Excellent. And then we've got Mark from the US.
Hi, I'm Mark Campbell from Schuckardi & Bacon. I'm the practice managing partner of the firm's class action group and business litigation group. My practice is primarily focused on consumer class actions, economic loss cases, although I handle individual products cases as well. And within the class action realm, I tend to focus on economic loss, damages experts, and consumer behavior experts, and the work they do leading up to damage claims in those cases. I've worked for all the major automobile manufacturers. I've worked on some of the large cases like the unintended acceleration, the Takata airbag cases, among others.
Excellent. And then last but not least, Edda.
My name is Edda Dolzer. I work in various global litigation department, and I focus on cross-border product liability cases. And when you take the pharmaceutical industry as an example, historically we've seen cases start in the US and then maybe spread to Canada, but there's been a recent shift. The litigation might still start in the US, but we see cases in many other jurisdictions, including for example, Australia or in Europe. And in Europe, this trend has accelerated even before the implementation of the new EU Product Liability Directive in many of the countries.
Excellent. And unfortunately, so Amanda, as you can see on the screen, was supposed to be with us and speaking from the Australian perspective. Unfortunately, she couldn't make it today. So if anybody in the audience wants to join us and speak from the Australian perspective, but we'll start with a bit of game. And so we've got some true false cards. And I just want to get some perspective from sort of the global perspective on different issues. So the first question is starting with discovery. In your jurisdiction, speaking to the panelists, discovery, thank you very much, discovery is often written and or depositions. True or false? Fascinating.
I'll go really high because in the U.S. it's a little out of control.
Yeah, Mark, can you speak to that just a little bit about how your perspective from the U.S.?
Sure. So in the U.S., there's lots of discovery tools, like many jurisdictions, but you find that those tools are often abused. In state courts, for example, in California, the standard for discovery is things that are relevant to the case, which makes sense, but also things that are reasonably calculated to lead to the discovery of admissible evidence, which leads to what I view as a lot of fishing expeditions in products cases and in class cases. The federal standard is a little more narrow, but discovery is just driven by interrogatories and requests for documents and requests for admissions and lots of depositions. And although there are some guardrails on all of those, it's a very expensive process in the US and a very time-consuming process in the US.
Class certification. So there was a multiple panels on class certification. So we won't spend a lot of time on this, but in your jurisdiction, true or false, Class certification is a required and important step for litigation. A little bit of both.
Depends if we're talking about competition claims, which
Yes.
we've obviously heard a lot about, or if we're talking about product liability.
Can you speak briefly to the product liability cases?
So those claims would be brought by way of group litigation orders, where you opt in and there's a group register. There is some element of assessment of those claimants and whether they meet certain thresholds, but it is nothing like the certification regime in the CAT. So a very different landscape.
All right, how about juries? In your jurisdiction, tort cases are often decided by juries. Mark, hold that way high.
Yeah, here we go again.
This is something that is very unique to U.S. litigation, I think, if you want to speak to that briefly.
Yeah, it's unique to U.S. litigation generally, and there's always interesting questions, right? Especially in products cases where you may have complex experts, technology issues that come into play, scientific issues that come into play, and you're asking 12 lay people who've basically taken off the street, not literally, but who have zero experience or background in these issues to make decisions. And they're going to hear testimony. Most of the time, you talk to jurors afterwards, they didn't quite understand the technology, didn't quite understand the science, but yet they're still tasked with deciding these cases, which is, it's the U.S. system for better or worse.
Briefly, I can comment on jury selection, the amount of time and effort it goes to pick a jury in the U.S. is just critical. People will often tell you that cases in the U.S. are won and lost on two big factors, the judge and the jury. And frankly, it's not often about picking the best jury, but finding those jurors who you really don't want on the juror. And we could spend hours talking about the psychology behind that. Punitive damages. In your jurisdiction, true or false, punitive damages are at stake. Sorry, Mark. Do you want to comment briefly on that and the billions that we've been seeing in the last few years?
Yeah, so in any tort claim where there's intentional conduct in the U.S., you're likely to find a claim for punitive damages. The standard is basically they're looking for malice, fraud, or oppression in the act or conduct of the defendants. And if the jury finds those, then of course they can award punitive damages. The amount will be dependent often on what the amount of compensatory damages turn out to be, what the wealth of the defendant is. I guess the only saving grace is the standard for punitive damages tends to be a bit higher for punitive damages than the preponderance of evidence standard we use in our courts. Typically clear and convincing evidence, which is some bar just slightly above preponderance, not like our beyond a reasonable doubt standard in criminal law, but certainly higher than preponderance of the evidence. And every case is a little different, but I think in many cases where the jury finds liability, they oftentimes find punitive damages as well.
I think that's right. And when I first started practicing, you'd hear the terms nuclear verdict, and I think it's just changed dramatically. If it used to be nuclear verdict, I don't know what you call them now, but the last 5 years, really since 2020, we've seen punitive damage numbers just quadruple what they used to be. Last question, true or false? In your view, product liability claims are becoming increasingly global. Oh, we all
agree. Finally.
Look at that unanimity. Edda, can you briefly comment on that, please?
Yes, I find it fascinating as a litigator to see that every aspect of the cases, product liability cases, is becoming more global. If you look at the facts, underlying facts, the companies are becoming bigger and bigger. They have subsidiaries in more countries. The supply chain is becoming more global. And then you don't even have to go to the big cases, but even the small cases can be, with a single plaintiff, can be global when the manufacturer is located in a different country than the first importer to EA, for example, or the distributor. And then, of course, collective actions. Like in the Netherlands, you have that opt-in possibility for plaintiffs that are located outside of the Netherlands that can then opt in. So, and those are only a few examples that show how much more product liability cases are becoming.
Mm-hmm. It's interesting. I heard somebody on the panel before us, I believe, use the term copycat litigation. And I think we used to see just that, but now I think we're seeing exactly what you're talking about, Edda, cases originating in all of these different countries and continents. And from a U.S. lawyer perspective, just the need for coordination among all of us is more important than ever. So I think that's a nice segue into the EU Product Liability Directive and some changes that we are all keeping an eye on. And I'd like to start with you, Katie, because I know you've been monitoring this closely for your clients and advising on this. Can you highlight for us some of the significant changes that we all need to be aware of?
Sure. So the directive is the strict liability regime for defective products. So claimants can bring claims for compensation for personal injury caused by defective products without having to establish fault. Historically, this is in relation to tangible products. The most significant change with the directive that comes into force next December is that it will apply to software. That is a really significant change. It includes AI systems, apps, connected products, all manner of tech, basically, now in scope into the strict liability regime. It applies to all businesses who place products on the EU market, so it's not only those who are based in the EU, so it is important for all of those outside of the EU who do use that as their market to be aware of it. There are a whole load of other changes, some of which codify some of the existing ECJ case law and others which are new, and I am conscious of time, so I'll just be very brief. But with the bringing in of tech and apps and software in particular, there's also more expansive damages that can be claimed. There's now medically recognised psychological harm. There's also loss or corruption of data. So there's a lot of commentary around what sort of mass claims might arise potentially in relation to software bugs or updates that impact apps. You may also see some sort of trivial claims because the cap on the damages threshold has been lifted, the €500 cap. So certainly some scope there for increase in mass claims. And then we've also got the defectiveness assessment has been expanded, so still remains an objective test, the safety standard that the public at large are entitled to expect. Still takes into account the warnings, instructions for use, etc., but now brings in specific tech aspects, so cybersecurity vulnerabilities, software updates, the continuous learning, adaptive nature, so particularly for AI systems, and then also importantly in the context of medical devices, and I know Edda will speak a bit about this as well, it also brings in mandatory safety standards as an assessment for defect, but not a presumption of defect, and also corrective action. So the extent to which a manufacturer might have conducted a recall will also now be considered in the context of whether or not a product is defective, and that is really important, and we could have a whole session on what that means for medical device companies in particular, but is for sure another reason why we may see an increase in litigation, and particularly mass claims. And then the most significant change, we've got disclosure, and we'll come on and talk about that, but the most significant change is the easing of the burden of proof by introducing rebuttable presumptions of defect and causation. If a manufacturer fails to produce and comply with the disclosure obligations, then the product can be deemed defective. If the product doesn't meet mandatory safety standards, it can be deemed defective. And there's a lot of commentary in the directive and in the recitals about the reasoning for putting these presumptions in, but predominantly aimed at AI systems and the challenges around understanding AI systems, their lack of transparency, the opaqueness, adaptive and continuous learning, etc. And then you also have presumptions of causation. Main one, I think, for the purposes of talking today, is in relation to where a claimant has a likelihood of demonstrating that the product is defective or contributed to the damage, but the court believes there is excessive technical difficulties in proving that due to the scientific and technical nature of the product, or indeed the case, which is a significant change, and as we see it on the defence side, does ease the burden of proof somewhat.
I mean, these are really, really big changes. I have a couple questions for you just to follow up, and then I'll turn to you, Edda. I've heard it made comment that there is concern that this is going to Americanize litigation in the EU, which I have to say is a very American way of looking at things, if I can make fun of us. But what is your perspective on that? Is that a concern that you have? How do you fall?
So I think the answer that most of the EU and UK lawyers would say is it isn't going to. It isn't introducing an American-style class action regime. For sure, it is introducing new disclosure and discovery, which for those civil law jurisdictions who don't necessarily have extensive discovery and disclosure mechanisms will be new, although I was talking to my German colleagues just in the break about the draft legislation in Germany, and a lot of the disclosure aspects there mirror what's already available, so it may not be as big an expansion in scope as people fear. So there are differences, and of course we don't have all of the differences we described in the quiz, right. But I think it will increase litigation, and it is a pro-consumer landscape. Some of the changes, though, have just been a way of codifying existing law, so it seems dramatic, it seems like significant changes, but in actual fact it's just putting into statute some of the law that's already been applied for many, many years. But I think those in the US who operate in the EU do need to be fully up to speed and need to prepare for it.
Edda, turning to you and on being prepared for it, as an in-house lawyer, how do you advise our audience to be prepared for this? And are there certain points on the medtech points that Katie raised that you're focused on?
So, like Katie, I think the new Product Liability Directive will lead to more litigation. Europe will become more litigious. I also think that it will become more procedurally complex, considering the new discovery rules. And it will also become more costly for corporations to defend their cases. And that trend needs to be seen together with the broader dynamics, including third-party litigation funding. But I feel that the merits of the case will still be data-driven. If you take the pharmaceutical industry, the liability will evolve around the science behind the case, so the outcome of the cases will still be data-driven and determined by the science in the pharmaceutical industry, for example.
Katie, in terms of being prepared, you made a comment that even U.S. companies need to be prepared. What are some ways or resources that people can be prepared, monitoring the changes as each of these countries then adapt their version?
Yes, I think absolutely monitoring how it's being transposed in the different member states, although at the moment, as I understand it, a lot of it is generally following the text of the directive, but definitely need to keep that under review. Need to assess whether your products and your clients' businesses' products are in scope, so carrying out risk assessments with the new expanded scope of the directive is really important. Looking at what you do need to do to prepare for the new disclosure obligations, and albeit in the US you're obviously used to the discovery, but you need to see how this test is going to be applied in the different member states. And it talks about documents that are at the manufacturer's disposal. Disposal is a really intended word. I mean, we're used to in the UK documents that are within our control and in our possession. There's always been the case with cross-border product liability cases and other type of litigation that you have to be careful about sharing those documents between the corporations in the different jurisdictions, and so you will need to think about document sharing protocols, you will need to think about legal privilege, confidentiality, trade secrets, and all of that I think will need to be conducted on a global scale when the business is at risk across different jurisdictions with different mechanisms coming into play.
Mark, going to just the product in itself, the new definition of product defect here, and you do a lot of economic analysis in terms of damages. From your perspective, how will the change in the definition of what is a product under this directive potentially change the damages analyses?
Well, first of all, I mean, you started off by talking about Americanizing the European system. I find this, frankly, terrifying. I mean, this is one of the places where I feel that maybe the U.S. hasn't quite gone this far. In most instances, a product in the U.S. is a tangible product. And so this change and the shift to AI and apps and software and technology is a big shift. In the U.S. and probably currently before the EU directive, that those type of things like software and technology, if they were integrated into a physical product, of course, would be fair game. But now they're fair game standing alone. And I think about it just in the context of U.S. cases, you know, the social media addiction. Most of those cases are brought as fraud cases, or they're brought as consumer behavior cases. But now are they products cases? And, you know, what impact does that have on a strict liability regime that suddenly those cases can now be thrown into that that type of claim? So it's significant, and I think it's going to drive up, as I think both my colleagues said, drive up the cost of litigation, but I think it's also going to drive up damages awards and settlement amounts.
Before we move to the U.S. more specifically, Katie, I want to wrap up this discussion piece with you. You touched a little bit on the mandatory disclosures. Anything else coming to mind that you want to just make sure everybody in the room, this is your opportunity, is aware of as they're thinking about what's coming down for the next year?
For the new disclosure obligations?
Correct.
Well, I think it's those jurisdictions that don't currently have a sort of extensive disclosure mechanism or obligation is to really work out where your documents are stored, how you need to update, document retention policies, how you need to put in processes for litigation hold notices. That's really important, and in global corporations can be extremely complicated, and just to not underestimate how, the length of time and processes involved to get all of that up and running, I think would be my advice.
Excellent advice. So Mark, turning to the U.S. a bit, we're going to skip Australia, sorry. But there is a lot going on there. But turning to U.S., I'd like to just start with you, just to highlight what trends, and I know we talked about verdicts a bit, but what trends are you seeing in the U.S. that you want the audience to be aware of?
I mean, the trend we're basically seeing is at least the damage calculations are showing much higher damage amounts than we've seen before in products cases, especially those that are in class actions. The theories of liability are becoming more creative to get there. You look at, I think the leading theory right now is the benefit of the bargain theory, that I overpaid for this product at the time of purchase. Had I known about this product defect or issue, I would have paid less. And we'll talk a little bit about some of the theories that are driving those valuations. There's the diminished or diminution of value claim, saying my product is worth less as a result of this defect. And then there's out-of-pocket costs like cost of repair, which are probably the easiest of the three categories of damages to understand and wrap your arms around. But in terms of the overpayment theories, especially we're seeing a lot of this in the Ninth Circuit, but not exclusive to the Ninth Circuit, this use of what's called a conjoint analysis. And a conjoint analysis is basically a survey methodology used by many companies, large companies in their marketing departments, to help them to really design products and directionally price products. And the way it works is you ask consumers questions about various features of a for example, an automobile. Would you like an automobile with leather seats or whatever the new fancy technology is? And you ask a series of questions, and through those questions you begin to understand what consumers value. And through that you can make decisions about how to design or how to market or how to price vehicles. Well, that theory of conjoint is now being used to calculate, or at least propose calculations of damages. And so they survey consumers, respondents, and they use this conjoint methodology where they ask them a series of questions about what their preferences are. And based on those preferences, they can identify the value or the overpayment damages for a particular defect. So for example, you have a vehicle with a defective transmission. You ask a series of questions: would you rather have this Toyota vehicle that works perfectly well, or this Ford vehicle that has a transmission issue? And while that may seem obvious, you would pick the Ford vehicle, there's a bunch of other attributes that are aligned with that particular product. So it could be, leather seats, it could be heated seats, it could be, technology-assisted driving. So when the consumers are making choices, they don't necessarily always gravitate towards the best vehicle in terms of whether the defect exists or not. But through those series of choices, they're shown up to 12 different screens, and they kind of pick each time. The plaintiff side believe they can determine pretty scientifically what damages are. As a defense lawyer, I'm very skeptical that that actually works. When you think about it, we have cases that sometimes the technology and the sales go back a decade. And what they're doing is today, they're asking respondents, what would you have paid for a vehicle 10 years ago that has these features or have these issues? And we just don't think it works. It's a good prospective tool for marketing. It's a terrible tool, in my opinion, for determining damages. But courts have adopted it, and it's pretty well recognized. There have been conjoints that have failed, for sure. There's been conjoints subject to 702 Daubert motions, but many courts are adopting them, and the damages are significant. Oftentimes you're seeing damages of 20, 30, or even more percent of the purchase price. And when you're talking about, high-priced products like automobiles, you're talking about tens of thousands of dollars per vehicle that are the claimed overpayment and damages. And so we're seeing hundreds of millions of dollars in damage claims in these product cases for automobiles, going into the billions sometimes. And so it's becoming significant. Just very quickly, from the defense side, we often rely on real-world data. We look at vehicle prices, especially prices in the used car market, or we look at product prices, and we see whether there's any indication that consumers really think this is a significant issue by looking to see whether the prices change in the market. And if the prices aren't changing, we think real-world evidence in real time as opposed to going back in the future to determine whether there's been any impact to the consumer as a result of this particular defect. In terms of out-of-pocket cost of repair, it's controversial in the sense that you don't always know if there's a repair for a particular product. There may or may not be. If there's a repair, you can look at warranty data. You can look at the cost of that warranty data to get a sense of what the cost of repair is. It's the easiest to prove if you have a fix, but you oftentimes don't have a fix for a particular product issue. But all of this leads, in the US anyways, to extremely, extremely high damage amounts, whether it's a high-priced vehicle like an automobile or some product that's, is in the lower price range. When you're talking about 20 to 30% of the purchase price or more in damages, overpayment damages, it becomes significant.
So we don't have the plaintiff lawyer perspective on our panel, so that will all go unrebutted and people can bring it up at lunch. Sticking with damages just for a minute, we touched on jury verdicts, Mark, too. Can you just comment on trends that you're seeing with respect to jury verdicts in the U.S.?
I mean, we've heard a lot about it. There's lots of, especially in single plaintiff cases, a lot of unbelievably large jury verdicts. In the class space, in the U.S., class actions aren't tried nearly as frequently as just single plaintiff product cases are. But nevertheless, we've seen in the class space, I think, in the last couple of years, a $425 million verdict against Google in a privacy case, a $102 million verdict against General Motors and a products class action related to an automobile defect. ExxonMobil in a benzene case, $816 million in a class action. So very large verdicts for those cases that are tried. I ran across a Bigelow tea case, and the verdict was $2.3 million. And I thought, oh, well, that's good for them, right? They managed to survive. But it was a particular product line, and it turned out that the damage theory in that case was an overpayment of 11% based on some misrepresentation about the product. I think it was a Made in the USA case. And it turns out their profit on that particular product was 12%. So it ate up basically all of their profits in terms of that verdict.
It's interesting. I commented earlier about seeing bigger nuclear verdicts, in the last few years. And I was looking at the data last night, and 5 years ago, you didn't see billion-dollar punitive damages. I'm not just saying that. That just wasn't a thing. And in the last year, there have been 17 jury verdicts in the U.S. where the punitive damages had at least $1 billion, which that's just a fundamental difference in terms of jury verdicts really since 2020. And I think we all sort of know what happened in 2020 and where the sentiment is, but there is just a general shift, more so than usual, in terms of anger with respect to jurors in the U.S. and distrust, I would say, of regulatory authorities in the U.S., which I think is one of the big drivers that we're seeing on sort of the jury verdict side.
Yeah, one thing I would say is interesting, right, and I'm sure you see this too, is oftentimes those billion-dollar verdicts with punitive damages are part of larger cases, right? MDLs, coordinated actions. And you can, in one state, in front of one jury, get a defense verdict. Another state have this billion-dollar, and so it's unpredictable. So for those doing business in the U.S., it's extremely difficult to predict what's going to happen. And as much jury research as you do, and as much as you try to have a jury that you think will not do something that's absolutely crazy, which I think billion-dollar punitive damage awards frankly are, you just don't know. It's really unpredictable.
Oh, that's right. A couple other changes that I'll just highlight briefly, and then we'll go to some more cross-border legal challenges. And I want to pick up on something that Rich was talking about on the last panel, the rule changes that we're seeing in MDLs and what I'll call sort of like the price of admission. And I think it dovetails quite a bit, Katie, with the changes that you were highlighting in the EU Product Liability Directive. And there's things from my perspective that is getting right that we're now trying to fix, and that's with respect to transparency of funding, and then also just this, what we can call price of admission. And the rule as it's coming out, as Rich pointed out, is fairly watered down, and it's going to come down to litigants explaining to the court what somebody needs to do before they file a case. But we now on sort of the back end are trying to fix, I think, what you guys are addressing from the front end, which is great. All right, so moving to some cross-border legal challenges, and we can sort of all talk about this together as we wrap. And I'd like to just start with you, and we can stick with the term copycat cases, but I think from your experience, you've seen a lot of cases that either start in the US or then expand or go into Australia, EU, and if you can just speak to that and some guidance that you have for us.
Yes, so, I mean, when cases start in the US, I think you now need to be aware that they could not only be limited to the US, but that they could spread to other countries, and what that means for how you set up those cases. And it's also like these high-level issues, but also then if you do the work, do it in a way that perhaps other countries can profit from. If you analyze the science, it could be helpful in other jurisdictions as well. So have that broader view, not only limited to the US, but think about what could come afterwards.
It is interesting. The social media aspect of litigation, and Mark, you're nodding along, has been fascinating to watch because we have seen in the US social media become a source for potential claimants in the US, but also sharing information. Maybe it's true, maybe it's false, but sharing information that drives litigation in a way that I don't think we had seen, 10 years before. Mark, you were nodding on that. Is that an experience that you've seen?
Absolutely. You can routinely find in most of the cases we litigate some Facebook post recruiting plaintiffs, asking, whether someone suffered a particular injury. It's a tool that plaintiffs' lawyers use frequently to recruit plaintiffs, for better or worse. I don't think I have an opinion on it, but we definitely see, it being used frequently.
But maybe I can add, I still see the courts being, they won't be deterred by that. So I think I have great faith in the courts that they will decide on the data and really go into the case, analyze the underlying facts, and then base their decision on that.
Katie, you have, I don't want to spend too much time on Dieselgate because I know that was a topic of another panel, but I do think we should touch on it. From your perspective, how has that made everything sort of different, if you will, here?
So just before I go into Dieselgate, it's worth saying as well, if it wasn't obvious, that the directive doesn't apply in the UK. The UK has the Consumer Protection Act. There's a Law Commission consultation that's just opened, and they will be looking at the Consumer Protection Act, and I'm sure they will be expanding the scope to software and various other changes, but not necessarily mirroring the directive. So sorry, I should have made that point earlier. So yeah, Dieselgate and the great panel this morning about the class action regimes in the UK. I mean, Dieselgate is highly unusual. It's 13 group litigation orders, all managed together. The court have taken an extremely interventionist approach, very, very proactive in the way they've case managed that. They've taken lead GLOs, which is the Mercedes litigation, then they've taken additional lead GLOs, which is 3 or 4 other car manufacturers, and then everybody else is non-lead, but they're all still in, and it's been a huge piece of litigation. And whilst the comments were made this morning that I do agree with in terms of it has demonstrated that the UK High Court can, inverted commas, cope with this litigation, I still think it's remained to be seen. It has been extremely high-pressured and extremely accelerated timeline, and whilst there are efficiencies, if anybody wants to read the costs hearing judgment and the £200 million cost that the claimants were seeking for only a third of their litigation work, for a third of the proceedings that got reduced down to 50 million, I think one would say it's not proving yet whether or not this is really feasible. But I think what it does demonstrate is that the court will be flexible in the UK and will have to be going forward if what we're saying, which a number of people today are saying, that we expect to see a lot more mass claims, and not necessarily just in the CAT, and we spoke about all the processes in the CAT today, but in the High Court, and what the High Court can do and indeed will do if it has to.
Mm-hmm. Again, I love these unrebutted comments that we can have up here. So there's been multiple comments this morning, and I was listening intently to all of the different panels, and there is a theme that I've heard throughout the day so far, that there's a concern that there's going to be more litigation outside of the US, that it's going to grow, that it's going to expand. And I just want to pause there before we get into some best practices and just open it up to all three of you. If you have concerns that it is going to grow, and what people can do about it, or what people should be thinking about.
I'm sure that it will grow, and I mean, I don't know. I know Katie gave so much advice what you can do to prepare for the new EU Product Liability Directive, and I thought that was very comprehensive. And I don't know if, as a company, there's really anything more than that, what we can do to prepare.
Mm-hmm.
Yeah, I think we're already seeing it bleed from the U.S. into other countries in the copycat lawsuits, as we talked about earlier. And the key thing, I think, is just communication. It's communicating internally, in-house, with the different legal teams. It's communicating with your outside lawyers. I can think of at least one example where I litigated a case for a while without knowing there was a companion case outside the United States, and with my in-house counterpart also not knowing that. And that's problematic. And so communication, I think, is key. Making sure that all legal teams are in touch, all legal teams know what's happening, so that there's no unpleasant surprises. Anything to add to that, Katie?
So I think I would probably just say that whilst I don't think the directive is Americanizing the EU litigation regime, I do think, though, that some new and novel litigation may arise in the EU first, particularly in relation to AI, software, gaming, autonomous vehicles, etc. Well, autonomous vehicles we will see in the US. But so I think it's important that we monitor how those new cases, those new products that are in scope, how they evolve and how the courts approach them, and then what that might mean cross-border.
Yeah, I completely agree with that, because we're just starting to see theories, as we touched on, like fraud theories in the social media addiction cases, with all sorts of different tech companies in the US. But it doesn't feel like the themes are landing quite right, and it'll be interesting to see how that applies here. Well, with our last few minutes remaining, we'll just end with just some closing remarks, lightning round, and I'm going to ask each of you. I'll go in order. Start with you, Katie, not to put you on the spot. But just for best key practice takeaway for everybody, and/or if you would just like to give, this is something really important in your jurisdiction that you haven't been able to touch on yet.
So I think in the UK, it is watch this space as to what will happen with the Consumer Protection Act, because it actually is quite unclear as to what changes will be made. So that needs to be monitored very carefully.
Okay, Mark?
Yeah, I know this has been said, but start now, get ahead of it, especially in terms of discovery and disclosure obligations. Take some lessons from what's going on in the US and what happens there, and prepare yourself, because it will be probably more onerous than you're used to.
And Edda?
Yeah, I think in the EU, it's monitoring the implementation of the EU Product Liability Directive and be aware of the differences that there are in each country. And there are really vast differences at the moment. And I think even when the directive has been implemented, there will be differences in the country that you might not be, in the different countries that you might not be aware of, to stay on top of the developments in the different countries.
So for mine, just to wrap up right before lunch, it would really be the need for coordination among all of us, both plaintiff and defense side of the bar, for sure. I would thank the conference for putting this great conference together and bringing us all together from a very global perspective. As litigation becomes increasingly global, it is so important to know who to reach out to for clients or friends or whomever in all of these different continents. And so with that, we will wrap, we'll move into lunch, we're available for questions, but I would encourage everybody to take an opportunity to meet somebody that they haven't met. We all flew all this way to be together, and that this is the time to network. Thank you very much.
Thank you.